File item 61, Senator Hill. Mr. Secretary, please read.
Senate Bill 1033 by Senator Hill, an act relating to healing arts.
Senator Hill.
Thank you, Madam President. Would you want to know if your doctor was on probation for serious offenses such as sexual misconduct, substance abuse, gross negligence, or a felony conviction related to patient care? This bill ensures that patients receive a one-page, easy-to-read notice summarizing the doctor's probation prior to their appointment. It only applies prospectively to doctors put on probation after January 1st, 2017. All of the information is already publicly available on the medical board's website, but it's typically over 200 pages of legal documents and hard to find and understand. In fact, one of my staff members took 15 minutes and 9 clicks before finding the probation information. I have a great deal of respect and appreciation for the medical community. They save lives every day. Over 99% of the 137,000 licensed physicians in the state are in good standing. This bill will only apply to about 100 doctors each year who end up on probation for serious offenses. Here are a few examples of the types of offenses that occurred in California that would cause a doctor to be on probation. Dr. Van Vu runs the California Pain Center in Huntington Beach. In recent years, 16 of his patients have died from drug overdoses. He was placed on probation by the medical board after an exhaustive investigation found that he was negligent in the deaths of 2 of his patients. A neurologist was found to have allowed unlicensed medical assistants to routinely give patients narcotic painkillers through infusion pumps. In one case, a woman was sent home after receiving more than 4 times the proper dose. She was found dead the next morning. The doctor is currently serving 5 years probation. A family practice doctor was found to be excessively prescribing controlled substances to patients, including one who received over 1,000 oxycodone tablets at one time. They also sold drugs for cash and provided free drugs to patients in exchange for sex. The doctor is currently serving 10 years probation. A primary care physician was found to have ordered more than 4 million tablets of prescription painkillers containing hydrocodone over a 15-month period. But investigators from the Drug Enforcement Agency could account for only 167,000 tablets. She is currently serving 7 years probation. A cardiologist was found to have performed gross negligence in treating 4 people with heart disease, including 2 who died. He was cited for exposing a patient to extremely excessive radiation, dictating a fictitious history and physical without seeing a patient, and dictating medical records weeks after patients died. He is currently serving 5 years probation. The medical board has a variety of tools to deal with physicians. They can issue a letter of reprimand for minor offenses, or they can revoke a license for serious offenses. But this is only after the Attorney General believes the case can meet the legal standard of clear and convincing evidence. Then they pursue the case and post charges to their website. Now, many of the cases end up on probation since the medical board wants to improve the doctor's behavior and the physician wants to keep practicing. Physicians are already required to inform, and I think this is important, members, physicians are already required to notify and inform the hospitals that they're affiliated with. They're also required to inform the medical malpractice insurers of their probation status. But their patients, the most important people in the healthcare continuum, have to seek out the information for themselves. Members, I want to leave you with one thought. The most recent medical board survey indicated that 30% of doctors on probation reoffend. 30%. That's almost 1 in 3. I want you to ask yourself, would you want your daughter, your son, your significant other, your parents, or your constituents to be seen by that one without their knowledge? Or do you feel as I do, as well as the Los Angeles Times, the Mercury News, the San Francisco Chronicle, the Contra Costa Times, the Oakland Tribune, and 82% of the population feels that you have a right to know? I ask for your aye vote, members.
Debate or discussion? Senator Pan.
Thank you, Madam President, Senators. First of all, I want to thank my good friend and colleague, Senator from San Mateo, for bringing up this very important issue. And I think we both share the goal that patients should be aware. In fact, it is public information, and I certainly understand his desire and support his desire that this information is made more available to the public and to patients who are receiving care. However, like many bills, sometimes the devil's in the details. So I actually do have a question, if I may be permitted to ask of the author.
Will you accept the question?
I will, thank you.
Without objection.
Well, thank you. From my understanding in the bill, that actually what will be presented to the patient is actually the allegation that the medical board made in conjunction, perhaps also with review from the Attorney General's office, but this is the allegation that's made prior to the opportunity for the physician who is being alleged to actually make their defense before the medical board, to present their side of the story. Can you please clarify what is to be actually presented to the patient in terms of, aside from the probation status, which is in terms of the information about that the physician has to relay to the patient?
Well, thank you for the question. What the process within the medical board and the complaint process begins with the medical board receives a complaint from a patient saying that they are concerned about the doctor's care or there's a problem that related to that. The medical board and staff physician review to determine its legitimacy. They triage that complaint. Then bogus complaints are dismissed, and then legitimate complaints are sent to the Department of Consumer Affairs for investigation. Now, if the Department of Consumer Affairs thinks offenses have occurred, they send the case to the Attorney General's office. The Attorney General gathers the evidence and interviews the physician, the patients, looks at the medical records, and talks with all of the stakeholders. They also get an expert physician in the same specialty area to review the case. Now, if the AG believes, and this is where the distinction comes in, believes that in the case would meet the legal standard of clear and convincing evidence, then they pursue the case and post those charges. And those charges that they post is what is called in the Department of Consumer Affairs the accusation. That is like the indictment. That is like the legal complaint in a court, in a legal defense. That is the complaint which in a legal situation, and in this case, is public information. Now, when that goes forward, then the Attorney General will pursue the case within the medical board. The physician can, at that point in time, look and see what their particular options are, and they can perhaps get a settlement that they would choose to accept. If that settlement is accepted, then the settlement and the probation would be the terms of that settlement, and they would have to go forward with that. What we would like to see, and what this bill states, is that those charges, just as in a criminal complaint, would be identified and outlined to give a full picture of the conditions under which the physician was practicing medicine and the charges and complaints that were filed against them. That would be included in the summary, as the medical board has made public and was in the newsletter that the medical board has been publishing up until a couple of years ago. They would outline in their newsletter publicly that they would send out all of the information that we're talking about, including in this disclosure.
On my own time, please. I want to thank you so much for the explanation. My concern is the way as you've described it, is that these are the charges. Like in a criminal case, charges are brought. I'm sure our prosecutors do a very thorough job before they bring up charges of looking at the evidence that they have. However, in our justice system, and I know then that the person who's being accused has the opportunity to make their formal defense. And my concern is that what you're asking is that, I mean, in the end, of course, there's an agreement that that this physician should be on probation, and they should certainly notify patients. But what they're being asked to present is actually the charges, not what the final result is of the after the opportunity to provide a defense. And so that is certainly a significant concern, because I do think everyone does have a right to due process in this country and in this state. And And I understand there was some discussion about this in committee as well. And so I hope that this, I think, very important issue of principle in my mind, not only for physicians, but for anyone, and it's not just physicians who are affected by this bill. I believe there's some other boards that are involved, that people have an opportunity to make their formal defense. And certainly if there's a settlement and someone says, I take no contest, you take the charge. But that we have a situation where that someone is able to have the opportunity to share their side of the story, to make their defense, and that they're not in a position where just because a charge has been made, that is hanging over their neck the entire time, that they are actually able to actually answer those charges. So with that, and I unfortunately am not able to support the bill at this time. I know there's some other technical issues related to how the notification, especially for physicians who may be communicating. I know we discussed some of this electronically or if not in person, and I appreciate that you said that you would try to address some of those issues as well. But I think that's a particularly fundamental issue that I'd be concerned about in this bill. Thank you so much.
Senator Allen.
Thank you, Madam President. I think that this bill bears some of the same marks of the bill we heard earlier from the senator from West Covina, which is that there's a problem that we know that we need gets addressed, and there's a lot of work that you have to do to get it through and make it something that we think is going to be ultimately fair. I very much agree with what you're trying to do in the sense that there's a disclosure issue, there's a right to know issue at play here. The LA Times editorialized about it. And and they had a piece that appeared in February that said parents need to know about doctor malpractice, and cited some of the cases that you mentioned before. This is ultimately a small number of doctors who are that we're talking about here. That being said, I want to just say that as this bill moves forward, assuming that it does, and I'm prepared to support it today because I think that the core goal is a good one. But here's a couple things that I really want to see you address and through the course of the bill's making its way through. And I'm going to be looking carefully at these amendments when it comes back for concurrence. First of all, there are some serious due process issues that have been raised, and I think that the senator from Sacramento did a good job. Ultimately, a charge is different than an admission or a finding. And they are fundamentally different. One thing that I would suggest you consider is the possibility of, and we talked a little bit about this, when a patient is coming before a doctor, the disclosure to say, look, this doctor is on probation. For more information about the probation status or reasons, please go to this website. To just make them aware of the fact that they're on probation, while not necessarily tarring them with a charge that hasn't been proven by anybody. That would at least go a little further toward addressing some of the core due process concerns that I have. The other thing that I'm concerned about are emergency situations. Now, I know that you took 2 amendments in the bill that are at the bottom of page 18, top of 19, that relate to emergency room visits. Those are exempted. And if someone is unconscious or otherwise unable to comprehend the disclosure, that's also exempted. But I can foresee other emergency situations. Let's say someone's bleeding profusely. They're still conscious. They could still conceivably make a decision, but ultimately, you want the doctor to treat them. You don't want them to have to first sign a disclosure saying that you understand the doctor's under probation for a paperwork violation. That would be ridiculous. That's not currently addressed in the current language of the bill as I read it, and I certainly hope that those things will be fixed as the bill moves forward. But I appreciate you trying to address this core question, which is the patient's right to know. The issues that you've raised are serious. I agree with the core intent, and that's why I'm supporting the bill today.
Senator Jackson.
I just want to add on, if I may, as the chair of the Senate Judiciary Committee, where it's our responsibility to make sure that due process is protected. And certainly the allegations and the testimony by the witnesses at the the hearing of this bill were quite compelling. There's no question about it. There are some bad doctors out there. There are bad lawyers. There are bad CPAs. They're usually less than 5% of the profession, and they do 90% of the damage. So we do need to clean up the profession. There's no question about it. It's in the benefit of everyone, certainly the patient, and certainly the practice itself, to maintain the quality and the integrity of what is otherwise an outstanding, dedicated group of men and women whose goal and whose purpose is to protect our safety and to provide the best health care they can. But that being said, that it's my recollection that when we had this discussion, we did discuss the due process issues, and we agreed that part of the problem probably was with the medical board itself. It's got to do a better job when allegations are made about malpractice. We all know who those bad docs are. The medical board has not maintained that level of protection that is necessary. So to say that we are going to essentially undermine due process because the medical board isn't doing its job, I think is a mistake. And I have thought long and hard about this. I do believe that we must allow due process to take place, because if we decide to let an agency, and the Attorney General does have, there is a standard that we require. They have to make a determination that it's likely that there is liability or culpability, I should say. But why have a judicial process if we're going to let a bureaucrat or an attorney general or one individual make that decision when we have a process that we are supposed to use, so that when a person is found to have violated their oath, has found to have committed malpractice, they will suffer those consequences. But to shortcut it and shortchange doctors, I think, undermines the integrity of our system of justice. And it is because of that that I can't support this bill. If it does go forward, I look forward to continuing to work with you on that. My recollection is that in committee, and I did look at the tape on this, that you would agree to take amendments that said only, that say that only when the physician was found guilty would they be required to be noticed to the patient. And again, that is part of the American system that we have. And so I hope that we can consider that and bring that back into the bill and get the medical board to do its job.
Any further discussion or debate? Senator Vidak. In case folks didn't hear Senator Vidak, his mic wasn't on, his comment was ditto. Any further discussion or debate? Seeing none, Senator Hill, please close.
Thank you, Madam President. I think what we're missing here when we talk about due process is that there is a due process. The due process has been followed through the system of the allegation, and that's interpreted as the actual legal charge that was filed against the physician, is then that works its way through the process. They're either found guilty of that through a trial, and then at that point, whatever they were found guilty of would then be disclosed on the statement. If they are found not to, if they have stipulated a decision, which is what the medical board in their newsletter describes, and if I may read one, Madam President, this is an example. Stipulated decision, no admissions, but charged with gross negligence, repeated negligent acts, sexual misconduct with a patient, and failure to maintain adequate and accurate medical record. Revoked, stayed, placed on 5 years probation with terms and conditions. That's the type of notice that we're talking about, and that is the information that is public today and which describes what the arrangement was and the stipulated decision, which is public information, and the patient has a right to know that. The final decision on the settlement of whatever that is, and that is the stipulated decision. For those reasons, members, I ask for your aye vote.
Thank you very much. Mr. Secretary, please call the roll.
Allen? Aye. Anderson? No. Bates? No. Bell? Aye. Berryhill? Block? Aye. Cannella? DeLeon? Fuller? No. Gaines? No. Galgiani? Aye. Glazer. Hall. Hancock. Hernandez. Aye. Hertzberg. Aye. Hill. Aye. Hueso. Huff. Jackson. Lara. Aye. Leno. Aye. Leyva. Aye. Liu. McGuire. Mendoza. Aye. Mitchell. Aye. Monning. Morlock. Morrell. Wynn. Nielsen. No. Pan. No. Pavley. Aye. Roth. Runner. Stone. No. Vidak. No. Wykowski. Volk.
Please call the absent members.
Berryhill. Canella. DeLeon. Glazer. Hall. Hancock. Hueso. Huff. Jackson. Liu. McGuire. Aye. Monning. Morlock. Morrell. Wynn. Roth. Runner. Wykowski. Wolk.
Senator Hill moves the call. File
Passes. Members, we are going to move to 3 bills that are on call. First bill is file item 61. No. Please call the absent members.
Berryhill. Canella. DeLeon. Glazer. Hall. Hancock. Hueso. Aye. Huff. Jackson. Jackson, no. Liu. Monning. Morlock. Morrell. Wynn. Aye. Roth. Runner. Wykowski. Wolk. Wynn, aye to no. Bates, aye to no. Glazer, no. Roth, no. Galgiani, aye to no.
Is Bates aye to no? Ayes 14, noes 13. Measure fails. Without objection, we will move to reconsideration. Ayes 39, noes 0.